This video tutorial on tenant eviction is brought to you by Amer USA, where you can screen tenants 24 hours a day. Step 1. Determine the tenancy violation. A landlord cannot begin eviction proceedings for just any reason. The laws of each state require specific tenancy violations to have occurred, and then specific notice requirements to be followed. So before beginning eviction proceedings, it is important to first determine what type of tenancy violation occurred. To keep matters simple for this video, we will discuss the two basic classifications: curable and incurable violations. What are curable violations? These are violations that allow for an opportunity to cure the problem before an eviction may proceed. Some examples of curable situations are being late on the rent and then bringing it current, boarding a pet and then finding it another home, or posting an unauthorized sign and then removing it. What are incurable violations? These are violations that allow landlords to terminate the tenancy without having to offer tenants a chance to cure the problem. An example of incurable situations are committing an act of domestic violence, repeatedly violating the same lease provisions, or failing to move after the lease term has expired. Step 2. Learn your state's time frame. You need to determine how much time you are required to give a tenant, if any, to cure and/or quit the tenancy. AmericanLandlord.com provides a list of timeframes for curable and incurable violations for each state. Some states require as much as 30 days, while others allow for the use of an immediate notice to quit, such as Arkansas, Georgia, Massachusetts, Minnesota, North Carolina, South Dakota, and West Virginia. Step 3. Find the right form to use. Now that you've determined the type of violation and how much time must be given to the tenant to either cure or quit, you need to complete one of the applicable forms. The notice to cure or quit is to be used for curable violations. The notice to quit is used for incurable violations. Each of these forms may be obtained by either visiting AmericanLandlord.com or by contacting the local clerk of the court for the jurisdiction where the rental property is located. Some local clerks will provide a free form packet, while others may charge a nominal fee. Step 4. Send and post your notice. Time is of the essence, and there should never be an ability for a tenant to put forth a defense of not receiving an eviction notice to delay proceedings. Therefore, it's always best to send a copy by certified mail and post another copy of the notice in a conspicuous place at the entry of the dwelling unit where one would be reasonably expected to see it. Step 5. Contact the clerk of the court. If the tenant fails to cure or quit by the time frame or date indicated in your notice, then you may proceed to seek the court's assistance by filing a lawsuit to take possession of the property. Since the procedures of each jurisdiction may vary, it is best to contact your local clerk of the court for specific information and help. For your review, we have summed up what generally happens next. Common eviction court procedures. The first step is to file a complaint and summons. This is what occurs after the tenant fails to comply with your first notice to cure or quit. Most clerks will have self-help packets and will provide assistance with filling out these forms. Expect to pay a court filing fee of a few $100s. The next step is to serve the tenant. the tenant needs to be notified to appear in court. It will cost about $50 to $75 to have a process server hand-deliver the summons. The next step is to simply wait for the tenant to respond. Most jurisdictions allow about a week. If the tenant fails to respond, you may file a motion for a final hearing or final judgment. If the tenant does respond with a defense, then the court will schedule a hearing to listen to both sides. In the end, if you win, the court awards a final judgment for possession. And if the tenant has not moved out after the court grants you possession, you may then file a writ for possession so law enforcement can then remove the tenant from the property. For additional laws and articles, visit AmericanLandlord.com.